Ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only. I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime if there's no one that I've hurt. Objection hearsay. Objection hearsay. I'm not a sovereign citizen.
Today we've got a guy in court who's acting like a sovereign citizen. He got caught speeding, but instead of just paying the fine, he pulled out a bunch of so-called legal lines he thinks will save him. The funny part? He keeps saying he's not a sovereign citizen, yet everything he's doing screams that he is. What do you guys think? Is he one or not?
Mr. Robinson, are you here?
I am here representing the name, ma'am.
All right, you need to start your video, please. And you are, is it Tremaine or Tremaine?
The name I'm representing is Tremaine.
Tremaine. And how do you pronounce your middle name?
J.
Tremaine J. Robinson.
On and for the record, ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only.
All right, anything else?
Yes, I would like to see evidence of a charging instrument.
Were you not given a copy of the ticket issued by Trooper Collins?
The charging instrument that I am referring to is a sworn affidavit of the client, of the person that I've hurt.
Now, this is a speeding ticket alleging that you did on March 27, 2023 at 8:48 a.m. operate a motor vehicle in Butler County, Kansas at the speed of 92 miles per hour when the posted maximum speed limit was 75 miles per hour. So this would have been out on the Kansas Turnpike, Highway I-35. Now, what else were you wanting to know, sir, as the allegations against you?
I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime.
This dude seriously believes you need a victim for there to be a case in court. Like, no, you can still be charged without someone being directly hurt. Laws like speeding tickets are there to protect everyone on the road, not just punish you if you hurt someone. Sovereign citizens love pretending it doesn't count unless someone got injured, but that's just not how the law works. Do you think he actually buys into this idea, or is he just playing dumb?
The victim would be the state of Kansas in that you violated the laws enacted to protect the people of the state of Kansas, but this is not the type of crime which would require or have individual names listed. So your next point, if any?
My next point is, as I said, ma'am, I'm not here to testify. I'm not here to plead. I would like to see the affidavit with 2 signatures for the person that I've hurt. If I didn't hurt anybody, there's no crime.
All right, well, I'm going to proceed. The subpoena was issued July 7, 2023 for Trooper Collins. Then on July 31st came a correspondence from the defendant as referred to by Mr. Regier herein. Looks like it's about 7 typed pages, and as counsel said, it's entitled Challenge for Jurisdiction and addressed to Butler County District Court Clerk, Butler County District Court Clerk, Office of the Attorney General Derek Schmidt. And it mentions subtitles under the following case law. I request case 2023 TR 1193 be dismissed. Pretty much standard language that is used by folks who call themselves or are considered sovereign citizens. Quote, it is on this date, July 27, 2023, I, Tremaine J. Robinson, it's Tremaine-J, Robinson in the county of the Seminole of the state of Florida and a zip code, a natural man, attorney in fact, is a living human being who's the beneficiary of Tremaine J. Robinson trademark. Swear that the information in my sworn statement is truthful to the best of my knowledge and understanding. I, Tremaine J. Robinson, beneficiary of Tremaine J. Robinson, revoke my signature on any and all pages of any and all tickets, summonses, contracts, and or agreements signed by the side of the road in the state of Kansas by Officer Collins K. And so here we are. Now, Mr. Robinson, normally I would be upset that you filed what appears to be in part a motion for discovery and you didn't get that. However, you did not address that document to anybody but Butler County District Court Clerk Traffic Court, Butler County District Court Traffic Court. You sent one to a P.O. box in Topeka, and then you sent a copy of it to the Attorney General. But you did not send it to the Butler County Attorney. Therefore, he did not know you were trying to get discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler attorney.
Okay, well, that's not on file. What you want to present that at this time?
Yes.
He really tried saying he mailed his discovery request the day before his hearing. That doesn't work. Discovery has to be sent way ahead of time so both sides can prepare. Sending it last minute is basically pointless. It feels like he's just trying to delay things instead of facing the ticket. Maybe he was confused, but come on, it's pretty obvious he's stalling.
I'm giving the benefit of, it's a multi-subject document, but this document filed by the defendant that I'm giving the benefit of including what he offers as a motion for discovery was not filed with the clerk until July 31st. So that was after the statutorily required 21 days. And then it was not filed upon the prosecutor who would have, or the witness who would have held any evidence, but rather again on Butler County Clerk in Topeka, Kansas, that to my knowledge doesn't exist, the Butler County Clerk in El Dorado, and Attorney General then Derek Schmidt in Topeka. And that's if it was served, if I take the defendant's benefit of the doubt, that it was saying it was served sometime yesterday before today's 1:30 trial, the court has to decide if that later time was reasonable. And I do not find that it was reasonably served on the county attorney. I am at this point going to say that any last minute motion for discovery is denied and we are prepared to go to trial. Now I've lost you, Mr. Robinson. Are you still somewhere available?
No.
What are you doing there with your computer?
Right now, I was looking for a document, but no, I am not.
I honestly can't tell if this guy is clueless or if he just thinks he's smarter than the judge. He hides his face, makes sarcastic comments, and acts like he knows it all. But court isn't a game, and the judge isn't playing along. Acting that way just makes things worse. He says he's not a sovereign citizen, but he's checking every box.
So please put yourself back in front of the camera. Follow the court's order, or you could be found in contempt. I don't want to do that. Thank you, sir.
Your Honor, in that particular case involved a sovereign citizen, where the court noted in the memorandum opinion.
Objection, hearsay. Objection, hearsay.
Case law is not considered hearsay or.
I'm not a sovereign citizen.
All right, he's not a sovereign citizen. Go ahead, Mr. Regier.
Yes, Your Honor. In that case, the Kansas Court of Appeals noted, quote, the defendant thinks the law does not apply to him. He avows that he, unlike other citizens, is sovereign and immune from prosecution. The court went on to address the issue of venue, which the court noted that, quote, venue is generally proper in the county where the crime was committed. I will address that momentarily, as well as referring to KSA 22-2602. Additionally, and perhaps most relevant to this court, the defendant in that case, quote, complains that his objections to the trial court's jurisdiction to prosecute him arise from the claim that he is a sovereign citizen. This is not the first appellate court to deal with such a claim. Another panel of this court used analysis of federal case law to reject a similar claim. And then quoting from Seventh Circuit and Eighth Circuit cases, quote, an individual's belief that his status as a sovereign citizen puts him beyond the jurisdiction of the courts has no conceivable validity in American law, regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being. That person is not beyond the jurisdiction of the courts. These theories should be rejected summarily, however they are presented. And with that, I would respectfully call my first witness to the stand.
All right. I do find that this court has jurisdiction and venue to proceed, and the arguments made by the defendant in the 7-page document referred to previously.
This guy even brought a 7-page legal guide he wrote himself. Too bad none of it is real law. Watching the judge dismiss it all is kind of funny. Sovereign citizens love writing these fake legal papers, but they never hold up. What's crazy is he seems to truly believe it's all legit, even though it's nonsense.
Write the defendant a citation for speeding?
Yes, I did.
Or an annual redirect? No further questions.
All right, Mr. Robinson, this is your opportunity to cross-examine the trooper. You can question him about his testimony. It's not quite time for you to give your own testimony, so these addresses to the trooper have to be in the form of question. You don't have to question him, but you can. Would you like to?
No.
All right. Mr. Regier, any further evidence?
None from the state, Your Honor.
Okay. The state rests then, Mr. Regier?
The state does so rest, Your Honor.
Mr. Robinson, the state rests. They have presented all the evidence they intend to. Would you like to present any evidence? Again, you don't have to. Your silence will not be used as a sign of guilt. But if you'd like the court to consider your position, I'd be happy to do so.
I don't understand.
Well, do you want to tell the court your version of what happened?
No.
All right. You don't wish to present any evidence then. Am I understanding you correctly?
The evidence that I tried to present, you won't give due process.
Okay. But do you want to give any testimony about the events leading up to this ticket, March 27, 2023?
No.
All right. Well, I will find the defendant guilty of speeding 92 and a 75. The scheduled fine is $87. Court costs are $108. The total due will be $195. Sir, you do have the right to appeal this proceeding. You can appeal it to the Kansas Court of Appeals. You have up to 14 days to file that notice of appeal. Your appeal bond will be in cash, the same as what your court costs and fines are. That's $195. Can you have this paid, this fine and cost paid in 14 days? Or do you...
By the end, he just looks defeated. He really thought he could walk into court, say a few made-up legal words, and make the ticket vanish. When the judge gave him his chance to ask the witness questions, he froze and blew it. Now he owes $195 and says he's going to appeal, but honestly, that's just going to fail too. You can't beat the law by ignoring it. Do you think he ever had a real chance, or was he just setting himself up from the start?